Hey guys, welcome back. Today's video is absolute chaos. We're covering 4 insane court hearings involving 2 different sovereign citizens, and things spiral out of control fast. First up is Joseph Shadowens, a soft-talking defendant I've covered before, but this time he completely loses it during a live video hearing. What starts as a normal court appearance quickly turns into a full courtroom meltdown, ending with the judge issuing a warrant for his arrest on the spot. And it gets even crazier. Less than 24 hours later, Joseph was arrested and forced to attend his next hearing from inside the jail. Trust me, this one goes completely off the rails.
All right, and then I have Mr. Shadowens by WebEx. This is 25T448, 25M318, 25M352, 25M375, 25M395, which are all People v. Joseph Shadowens. Checking to see if Natalie Chantal is on WebEx. Not hearing a response. All right, so Mr. Shadowens, I have reviewed the report that was provided by the Office of Civil and Forensic Mental Health. They emailed you December 5th to initiate the evaluation assignment to an evaluator. You responded that same day saying, "Good morning, the order is illegal given absent proof of jurisdiction that was challenged in retaliation for exposing crimes. I do not consent to an evaluation," and stated that on record. Judge said, quote, "You don't have to talk to mental health. Thank you for your time and consideration. Merry Christmas." So, Mr. Shadowens, you have 2 options at this point. One, you can agree to cooperate with the evaluator and have an evaluation conducted, signing any releases that are necessary for the evaluator to obtain records and evaluate you. That's one option. The second option is that I issue a warrant for your arrest and the order that you be held without bond until that evaluation is completed. And I would like to say that they will have that evaluation done within the statutory time frame, but it is rare that that happens. So you would be in custody potentially for up to, well, I wouldn't be surprised, 30 days. Which would you like to choose, sir?
Joseph Wayne Shadowens, grantor and beneficiary, appearing by special appearance to settle these matters. Good morning, trustee. So, did I or did I not waive the court?
Sir, I do have jurisdiction over this matter. We've discussed it before.
Answer the question, please. Yes or no.
I don't have to answer your questions, Mr. Shadowens.
You. I'm here to settle this matter, Your Honor. I have not seen any certified accounting nor charging instruments, bid performance payment bonds. A full record of all certified accounting is demanded. My right to settle these matters via set-off settlement, discharge, and closure of all accounts via equitable subrogation is demanded.
None of that
notice of motion order to revoke or vest the trust.
None of that is.
Jurisdiction is again challenged and must be proven. That's both IMREM and statutory jurisdiction.
So, Mr.
I have not fled in these
Shadowens,
matters. I have not been off. I haven't even had an offer. So you have ruled from the bench. Let the record show you have ruled from the bench, issued a void judgment with a lawful jurisdiction challenge unproven, that the state on 2 occasions raised themselves, not affording me the right to a rebuttal. Prove up the claim of jurisdiction or cease and desist. Now, a full accounting record, certified accounting, is demanded. My right to equitable subrogation is demanded.
This is a criminal case, not some insurance claim dispute, so your whole subrogation rights argument makes absolutely no sense here. But now he's demanding that the judge prove jurisdiction on the record, and surprisingly, she's about to do exactly that. What happens next completely shuts down his entire argument.
Okay. Thank you, Mr. Shadowens. As I've mentioned multiple times, the court does have authority over this matter.
I have jurisdiction because I
Mr.
say
Shadowens,
so. It's not evidence. It's a question of evidence. Prove up the claim. Be still. Do not threaten me again.
Okay.
You will provide the accounting, or you will talk to federal agents. It's over.
Thank
Now
you,
it's
Mr.
over.
Shadowens.
Dismiss this case. Throw this out right now, or you're getting sued, Judge. You're getting sued, trustee. Do not threaten me again.
Thank you,
My
Mr.
right to
Shadowens.
subrogation is demanded. You will not use my service-connected disabilities against me for issues the state has created. Now, I have clean hands. I will not participate in public and private conflict. Now settle these matters.
Okay. So the court is going to issue a
The court's going
warrant.
to do nothing. The court will do nothing. The court's
The
jurisdiction
court
is
is
changed.
issuing warrants. I'm going to have to mute you, Mr. Shadowens, because I have to make a record. All right, so I'm muting Mr. Shadowens. So I do find that I have jurisdiction over this matter under Article 6 of the Colorado Constitution, Sections 1 and 16, as well as 13-6-106. I have subject matter jurisdiction under the Colorado Constitution, Section 17, and statutes 18-1-201, 13-6-106. I have jurisdiction over traffic infraction matters under Articles 1 and 16 of the Colorado Constitution and 42-4-1708. I have subject matter jurisdiction under Colorado Constitution, Section 17, and Colorado Revised Statute 42-4-1708. I also have personal jurisdiction over Mr. Shadowens based on issuances of a summons in 25T448, in 25M395, in 25, I have a complaint and information in that case. I have, in 25M, I have also a complaint and information. And I have in 25M 318, I have a complaint and information in that case as well. So I do have the charging documents have been served on the defendant. So I do have personal jurisdiction over him. I am going to issue warrants in each of these cases, and they will be no bond holds because Mr. Shadowens is refusing to participate in a competency evaluation. He will be held without bond in each of these 5 cases, pending completion of the evaluation, and I will issue new orders for an in-custody evaluation upon him being taken into custody. I'm now going to go ahead and unmute Mr. Shadowens, but I have made my ruling. Thank you.
So the judge just laid out every statute and legal authority that gives the court jurisdiction over the case completely on the record. But just like every other sovereign citizen I've covered, that still wasn't enough for him. Instead of accepting the answer, he doubles down, completely loses control, and starts crashing out on the judge in the middle of the hearing. And from this point on, the entire courtroom turns into absolute chaos.
If you go ahead and put men in harm's way because of a controversy that you created via aggravated identity theft, fraud, waste, abuse, embezzlement, and tax evasion, The thief is caught and must repay. Now you are a trustee and a secondary obligor. I will have nothing to do with public and private conflict that you yourself created after demanding settlement by my right of subrogation. Are you allergic to money? Do you not want to get paid? You have no victims. Okay.
Thank you, Mr.
Now you want to
Shadowens.
use my mental health, my service-connected disabilities, that you are clearly aggravating yourself, deny me the treatment that I'm already in and exceeding. I'm actually leading multiple treatment groups, but you want to play the victim and the blame game while acting as a tyrant and a menace to society.
Thank
So
you,
you can
Mr.
do all the void
Shadowens.
judgments you want to. For the record, trustee Teresa Kilgore has yet again ruled from the bench under Vice Admiralty color of law, issuing void judgments, knowingly putting men in harm's way, threatening the life of a disabled veteran.
Thank you, Mr.
You will
Shadowens.
cease and desist. Your orders are null and void. You
Thank
have
you.
72 hours to report to me with full accounting. My right to equitable subrogation is demanded. Your jurisdiction, subject matter, in res, and stat is again challenged and cannot proceed absent evidentiary proof of jurisdiction.
Thank you,
I have
Mr.
jurisdiction
Shadowens.
because I said I'm not done speaking. Don't interrupt me.
I am
Sit
going
down,
to turn
shut
you
up.
off. So,
Step
Mr.
down. You're a criminal clown. Who do you think you are?
This call
I
will
would
be
also
recorded.
find that
How
Mr.
dare
Shadowens
you?
is
dare you?
engaging in direct contempt. I am going to mute him at
You
this
are in
time.
contempt. You have a
Well, that escalated fast. In less than 3 minutes, this hearing went from a routine court appearance to the judge issuing a warrant for his arrest live on the record. And unlike a lot of these courtroom threats, this one was carried out immediately. Police moved in fast and arrested him shortly after his complete meltdown in court. Now we're moving to the very next hearing, which took place the following day. And as you can already see, he's no longer appearing from home. He's joining the court straight from jail after that disastrous crash out.
It looks like I have Mr. Shadowens back. Yeah, there is one that was issued on November 21st of 2025. So I think they do that out of the clerk's office. Maybe they have it's just a form that they send out. Yeah, they send that out that way. All right. Back on the record in 25T448, 25M318, 25M352, 25M375, 25M395, all people v. Joseph Shadowens, who appears by WebEx from the Teller County Jail. I also have Mr. Machechik, District Attorney, present by WebEx. I have Mr. Gologly present by WebEx. And I don't know if there's any information that you might have, Mr. Gologly.
Yes, Your Honor, I did speak to Mr. Shadowens. He indicated that he would like to remain silent, but that he would speak with the evaluator. So that is our request today, is that he be allowed to do that out of custody.
Okay. All right. So, Mr. Shadowens, what we're going to do is set a court date for receipt of that competency evaluation. You are ordered to cooperate with the evaluator, as I mentioned. If you choose not to cooperate, and the result of the lack of cooperation is not the result of a developmental disability or mental disability, your non-cooperation with the competency evaluator and other personnel providing ancillary services may be admissible in a competency or restoration hearing. When you are non-cooperative, an opinion of competency may be rendered by the evaluator based upon other information they have in the file, confessions, admissions, and any other evidence of circumstances surrounding the commission of the offenses, as well as the known medical and social history of the defendant, and the opinion may be admissible into evidence at any competency or restoration hearing. You are also ordered, if you choose not to talk to the evaluator, you are still ordered. And so if the court gets a report that you have failed to provide releases of information to the CHDS people or to the evaluator so that they can obtain your records, then regarding mental health, then that will also be a violation of this order and may result in a warrant for your arrest, revocation of bond, and a warrant for your arrest. I'm going to make sure that you have a copy of this. We'll send this order that was issued back on December 2nd to you, so you can review it. We'll set that next court date, which will be, I guess, maybe 60 days or so.
60.
Mm-hmm.
April 27th at 8:30.
April 27th at 8:30. And let me think what else. Oh, I am well, we did not revoke bond yesterday because I had hoped that you would make a wise decision about cooperating with the evaluation and would be able to allow you to be released from custody. So I don't really have to reinstate the bonds because we did not revoke them yesterday. I'm sorry?
You issued warrants that nearly led to the neighborhood being burned down. After I revoked and revested the bonds to recoup damages created from, okay, so that issue does need to be addressed. I will allow counsel to handle that since you appointed counsel. If you issued warrants, as the sheriff's office refused to provide a bond request and a 911 phone call demanding warrants. So what are you doing? I showed up to settle the matter.
No, you didn't get arrested because the system was corrupt or because the court was against you. You got arrested because you walked into court, acted completely disrespectful, ignored every warning from the judge, and turned the hearing into a disaster with your contemptuous behavior. Actions have consequences, and in this case, the judge finally had enough. And honestly, based on everything we just watched unfold, it was completely deserved.
So, Mr. Shadowens, I do want to make sure you understand that Mr. Gologly can represent you while you're in custody, but if you wish to have the assistance of a public defender after you're out of custody, you will have to apply for their services, which means you have to go to the office of the public defender in Colorado Springs and submit an application along with proof of your income for the past 30 days, because unless you want me to take your testimony regarding your income, I mean, I guess I could assist in that way, but I can't, just to let you know, the public defender they have rules they have to follow.
I understand. Thank you.
Thank you.
The issue of bond is you issued warrants after I showed up to settle the matter for set-off, settlement, discharge, and cancellation. You revoked and revested and then sent men with guns and badges over a misdemeanor without showing me the charging instruments, without showing me any evidence. So I mean, settle the matter, Your Honor.
Thank you, Mr. Shadowens. My role in this case is simply to be the judge in the case. The prosecutors of these matters, that is the district attorney's office, and so that it is not my job to dismiss these cases at this stage. All right.
I'm adjudicating for the state. I don't even know who this man is. This is like the fifth guy. I have no evidence, so I'll go talk to an evaluator, so you all can play the crazy card, okay?
Thank
And
you.
I'll just handle it with $100 million tort claims, like you don't have a victim here. You almost burned down a veteran community with void judgments, with 3 lawful jurisdiction challenges on the table. Like that's, I mean, you could say I'm incompetent, Your Honor. I haven't raised the issue. I'm at common law, you're at some other admiralty law as evidenced by prima facie evidence behind you. That's just the way I talk, brother. I'm not yelling at a judge, so you can hear me. I'm not being disrespectful, I'm being disrespected. This is kidnapping. Straight up, and you all know it is.
Thank you. Thanks, Mr. Shadowens. I don't want you to start getting escalated. You escalated yesterday to the point where you were calling me names. I didn't find you in contempt of court yesterday, but I don't want you to get escalated at this stage, because then I will be, contempt of court, direct contempt, calling judges names and yelling at them can result in a jail sentence. All right? So just keep that in mind. Thank you, Mr. Shadowens. Thank you, deputies.
What is the ruling?
The ruling is that I do have jurisdiction. I am not dismissing any of these cases, sir.
Out of all the sovereign citizens I've covered, this might be the first one who genuinely needs a competency hearing. You'd have to be completely out of your mind to speak to a judge that way and then somehow blame her after your own actions nearly turned the neighborhood into chaos when police came to execute the warrant for your arrest. But somehow, this video only gets crazier from here, because now we move to our next hearing, where another sovereign citizen walks into court convinced that his stack of imaginary legal paperwork is basically a get-out-of-jail-free card, only for the judge to shut down his nonsense before he can even get started.
Mr. Stanley here, 25 CR 745, People versus Michael Stanley. We are here on a possible disposition. Mr. Stanley, we have several motions pending. I know several of them are yours, and I'm going to be issuing all of those here shortly.
Okay.
Mr. Hillier also had a motion. Have you seen the people's motion as to the request for evaluation?
No, sir.
All right. That was not filed under seal, I believe?
Not under seal, Your Honor.
No. And so it's available to him. So basically what the people are asking me, and I wanted to hear from you on this, that's one of the reasons I want to talk, is they're asking me to order an evaluation for your competency based on your filings.
I think that's pretty ridiculous. I think once you see the other motions and the language in them, they're pretty straight to the point. And what's contained on the record backing that up, the fine lining should come through to all parties. It's a pretty common tactic by them to try to do that when they know they're backed in the corner and don't have much of a case, such as this case. So it wouldn't be the first time I heard that, but I would say that I'm probably pretty competent according to the language in the motions.
Mr. Hillier, I don't know if you have any further record to make in this matter. Obviously, I think that I recognize the content of the motions to be of a particular outlook, but I guess I wanted to find out if there was any record you're requesting.
No additional record. The people would still request a competency evaluation. I've reviewed Mr. Stanley's motions, and while there is legal language in there with some sort of goal in mind, we do rest on the language of our motion, which we don't mean to be sounding insulting, but quite...
Objection. We already know about their trying to keep me in proximity of the victim and their genius of that whole nature. I mean, this whole comment, it's pretty obvious what they're trying to do.
I understand. I heard from you. I'm going to hear from him as well.
Garbage.
You can finish your comment there.
Thank you, Your Honor. We do believe a competency motion is a competency evaluation is appropriate at this time. We don't believe that the motions, for the most part, don't make any particular legal sense, and we therefore believe that given the volume of motions the defendant has filed, the nature of those motions, we do believe a competency evaluation is appropriate at this time.
I'm not going to order a competency evaluation at this time. Once again, I recognize the content for what it is. I understand it's the word we use is sovereign citizen language in there. What I'm telling you right now is, because I want to address real briefly, we got a letter that I published to the people. I don't know if the people saw that. It was from a family member.
It was it recently, Judge?
I can't remember. It was a week or two ago. My point is I want to make this clear because there's these references to the county court, and I want to make it clear that the county court is not like my underling. They have their own court. This is my court. I did grant your request for a change to bond alterations, but as I stated at the time, I cannot control how other courts do that.
Okay.
So I don't get to order another judge, even if it's a county court level. They handle misdemeanors, we handle felonies. That's the delineation, not some sort of a overruling hierarchy unless there's an appeal to me. Okay. So I just want to make that clear that I have no ability to grant that relief. I can't order Judge Lynch or Judge Villasenor or any other judge to do something like that. I just want to make that clear.
I appreciate
so that because it's important for that to make that clear because we will have to address that. At this time, I'm not going to order a competency evaluation just based on my recognition of the, I won't call it a philosophical bend of this with the UCC ones and all this and the without, I mean, I understand what that is, okay? It's obviously a discredited and refuted legal doctrine. However, I don't know that rises to the level of incompetent to, I don't think I have enough yet at this point to order that. As we proceed, though, I'm going to set this matter in for for a next hearing. Is there any, because you're representing yourself.
Yes, sir.
We've gone over the advisement about that.
Yes, sir.
And you still intend to represent yourself?
Yeah, I'm willing to take this to a jury trial. And
okay, that's fine.
That's fine. And I don't really feel like I need any kind of representation for.
And you certainly, that's your right as well, is to represent yourself. What I'm asking is, do you have contact information with the DAs so that this matter can be addressed for our next hearing?
Yeah, I don't see why not. I mean, they have all my address and everything else. I mean, I've been corresponding and serving them with the notice of the motions, obviously, which they got. My question to you is, am I going to be arrested today?
Short answer, yes. Long answer, absolutely yes. At this point, the court has clearly had enough, and the deputy standing right behind him isn't there by accident. He's already preparing for exactly where this hearing is headed. You can practically feel the arrest coming before the judge even says the words out loud, and somehow he still doesn't realize just how bad this situation is about to get.
There is a warrant out of another division that is not mine. That there is a warrant that is active. And
so are these guys going to arrest me right here?
They're at the end of this proceeding, they will.
Okay.
But again, that is not my warrant. That is from another division. So you will be, but let's set our next court date. We're setting, now, if you said you intend to take this to trial, do you want me to set this for an arraignment? Which means you would be making your not guilty plea at that time and we would set it for trial?
Sure.
We will set this next matter for an arraignment.
So I came out here out of respect for your court. My question to you is, should I have showed up on WebEx again?
Once
I mean,
again,
would you have allowed me to appear on WebEx?
I do not allow anybody to appear on WebEx if they have an active warrant.
Okay. How am I able to get that quash if he's going to
from that judge?
Okay, but he's actively like fighting me, and every kind of ruling you make has been the back and forth.
My rulings and his rulings have to do with our own cases.
Okay.
So my rulings matter in my case, and your bond conditions were amended in my case, but I cannot make him do that for his.
Okay, and did you say that, is there a way to transfer it to this court, or does it have to stay at that lower level?
It is in his courtroom until it's not. That's what I can tell you. And it is in his courtroom. Okay. So that is his case. I don't take misdemeanor cases. We're here for felony cases.
Yeah, I understand that.
All right, so we have the 5th of March at 9:30 as our next hearing, and it'll be an arraignment so that you can enter your not guilty plea and we can set the matter for trial.
Okay.
If that's what you're asking to do.
Yeah.
Okay, so we're going to set for the 5th. Actually, we're going to make it 10:30. Hopefully that makes it easier for you. And for arraignment, if you're going to enter a plea, and whether that's a guilty or not guilty plea, we do ask that you be here in person so that you can enter the plea and we can set for trial.
Okay.
All right, because we have to make certain advisements to you about understanding the charges, the possible penalties to those charges, et cetera, and moving forward to a jury trial.
Okay.
All right. So we have our date set. Is there anything else to address? And I will be issuing orders. We've gotten a lot of them, and I've had trials, so I have them ready. We will be issuing orders on the motions that are currently ripe. I think some are not ripe yet, and that we have to hear responses.
Okay.
All right. Anything else to address, Mr. Hillier?
No, Your Honor.
And what's the next dates? I'm sorry.
The 5th of March at 10:30, and that is for your arraignment, for you to enter your plea and set this matter for trial,
Okay.
as you requested. That is your request, correct?
Yes.
Okay, just need to make sure that's clear. You can exchange any information you need to with the prosecution so that you can talk with them.
Okay.
If you intend to discuss any matters with them prior to that, because you represent yourself, they can talk directly to you. But I have to give you the warning, of course, as always, as I tell everybody. If anything you do say to them, make sure you don't incriminate yourself.
Okay. Sounds good.
All right, thank you. I'll ask you to have a seat over here.
All right, so after getting arrested on that outstanding warrant from another county, he eventually managed to bond out and appeared at his next hearing over video call. But unlike the previous courtroom explosions, this hearing is mostly just nonstop complaining, excuses, and frustration as reality finally starts catching up with him. Because it turns out being a sovereign citizen doesn't magically free you from consequences. It just leaves you paying more fines, dealing with more warrants, and learning the hard way that this fantasy ideology costs a lot more than it ever pays back.
All right, our last 10:30 is Mr. Stanley, who appears on WebEx 25 CR 745, People versus Michael Stanley. Now, Mr. Stanley, I saw your motion. However, I wanted to address it with you here because I don't know if you intend to arraign today or not. Let me get you unmuted. What I remember telling you when you were last here is that for a plea, not guilty or otherwise, we need to have you in person to make that plea unless the people are willing to waive any objection. Do you intend to plead not guilty and set for trial today, or did you intend, because we can set this for a time when you can get here so that I can accommodate the hardships of travel.
I'm so sorry. I just can't seem to catch a break. I can't make this stuff up. But whatever, if the state's willing to go with it, I want to expedite things. I don't mean to hold things up. I feel real bad. So if they're willing, I will enter a not guilty if we could do so today, please.
Do people object to?
People would prefer to have him in person, a standard procedure.
And there's reasons for that. We do it in person. This is a trial setting. It's a plea receipt. We accommodate in many ways. Is there a time and date that I could set that would be convenient for you to get here so that I can help accommodate your travels?
Yeah, I'm sorry. Going back and forth and having new bonds written on my name makes things quite difficult. If the DA could take that into consideration. With that, I'm probably going to be looking to move out of Pinedale. Not that I'm coming down to Fort Collins because I don't really like the scenario down there, but maybe somewhere closer in Wyoming. So I don't know what the calendar, how it reflects, if it's 2 weeks or a month. I know it could go anywhere from 14 to 28 days. So,
if you're amenable to the 26th, we have some dates open. That's about 2 weeks out. Is that enough time to get you some arrangements to get here for the plea entry? That's 3 weeks.
To maybe push that. Yeah, is there any way to push that maybe just a little bit closer to like 28 days or a month?
Let's see what we have to offer.
A lot of it is if I can get the lower court to kind of do what I've been trying to do, and kind of, obviously I'm not in favor with him for reasons stuck to myself, but if I can get him to get on board, it would alleviate all this issue, to be honest.
How about April 2nd at 11?
Write this down.
11:30.
Yeah,
I'm sorry, 11:30.
I'm sorry. This is 4/2/26 at 11 a.m.
11:30.
Oh, 11:30. I'm sorry.
Yeah.
11:30. Okay, let's. Yeah, let's pencil that in, and hopefully maybe I can work with this guy in the county court because I already know there's probably another warrant out. But it's just been costing me a lot of money in lodging and travels, and that recent thing that happened. I mean, we're talking about $2,000 a trip at this point. I mean, it's, I don't know who's got this kind of money, but anyways, yeah, I guess we'll
Right.
pencil that in.
And that's later in the day, so it should accommodate some travel. So we have,
Well, and hopefully,
Go
yeah,
ahead.
hopefully, like I said, I can get a hold of Mr. Lynch, or Judge Lynch, I should say, and have him remedy the warrant situation. Hopefully, consolidate the cases, but I can't seem to get him to budge right now.
all right, well, I'll leave that between you and him, and we'll see you on the 2nd of April, 11:30 for an arraignment, and I will take your not guilty plea at that time and set it for trial.
All right,
And we,
You have a
in
good day.
person, as you know. Thank you.
All right, you have a good day, Finley. Honorable Finley. Have a good day, sir. We're good? Okay, I'm leaving.
Yep, you're welcome to leave. Thank you.
All right, guys, that's going to wrap up today's video. And honestly, with the way both of these sovereign citizens are spiraling, there's almost no chance this is the last time we'll be hearing about them. You already know there are going to be more courtroom meltdowns, more failed legal arguments, and probably even more arrests coming down the line. And when those updates happen, I'll bring them straight to you. So if you enjoyed today's chaos, make sure to like the video, subscribe to the channel, and turn on notifications so you don't miss the next unbelievable courtroom disaster.